The most complete title protection is offered by A, abstract of title, B, extended coverage policy, C, standard title policy, D, certificate of title.
What is the A?
So extended coverage policy. Yeah, this one was tricky because they don't even explain this really as a definition in the book.
Mm,
Let's see. The most complete title protection is offered by an extended coverage policy. In addition to standard policy coverage, an extended policy offers protection against unrecorded liens. Okay. Yeah, that was tricky. I would
yeah,
have
that
also
makes
said abstract of title. The one that I was least likely to pick.
sense.
So knowing that the most complete title protection is offered by an extended coverage policy. That would be the best answer. All right. A buyer insists that a seller sign a document that states there are no unrecorded liens against the property and the seller is the rightful and lawful owner. The buyer is asking the seller to sign A, property disclosure, B, affidavit of title, C, hypothecation clause, or D, agency disclosure.
Would it be if there are no unrecorded liens against the property?
Really? Which one did you say?
About A.
Okay.
Disclosure statement.
Yeah, maybe right. Okay. So
And
it
I'm
would be
starting
B,
to say affidavit too. I'm starting to say
right? Yeah, so affidavit title is sworn statement by the seller that title is good. Got it. So I always forget what this. So the affidavit of title is a sworn statement by the seller that title is good. Perfect. So this is what the seller signs to tell the buyer that there are no liens on the property. Okay. Once a person has gone to the courthouse and reviewed all documents pertaining to the property they intend to buy, they are said to have A, constructive notice, B, ad valorem notice, C, actual notice, or D, caveat emptor.
see.
Good job. Yep. So that is actual notice. Well, I like the question rationale because it explains the definition of each one. Okay. Actual notice refers to something an individual has seen or knows to be true. B, documents recorded at the courthouse regarding a person's property. C, the reasons that an individual should record a deed. Or D, the information an individual is presumed to know.
B. Let me just do that.
B, right? Yeah. Hmm.
Oh, what? Can we just
Right?
do that?
Right? Yeah. Right? Right. So,
Okay, okay.
so it just so happened that they were at the place, but it's actually documents recorded at courthouse. I mean, sorry, so it's actually something an individual has seen or knows to be true.
Okay.
Yeah, that was tricky. No wonder they did it as a second question. Okay. Okay. Which statement concerning a settlement or closing statement is true? A, the real estate agent's commission is a credit to the buyer's side of closing. B, a closing statement is a simultaneously listing of debits and credits to the respective buyer and seller. C, there is a corresponding debit for seller and credit for a buyer for all charges on closing statement. Or D, there is a corresponding credit for a buyer and debit for a seller on all charges on the closing statement. So on this, I believe it is going to be B. It is the closing statement that shows both debits and credits to both the buyers and the sellers. Yeah. So it'll show you a breakdown of both parties on the closing statement.
Yeah, I'm a little lost on that one.
Yeah. Okay. Okay. Cool. So we can do contracts and then we can always do another thing of transfer to title.
Okay.
Perfect. All right. Which are liquidated damages? A, losses suffered when liquidating a business. B, an amount the parties agree on to settle a potential dispute. C, a cashier's check used to empty a broker's trust account. Or D, paper money that has been soaked for 24 hours.
Um, is it B
Yeah,
or A?
yeah, B. It is B. Good job. Yeah. So liquidated damages are an amount of money the parties agree upon before entering into a contract, which will serve as compensation in case of a breach. So in case anybody breaks the contract, aka breaches the contract, they'll
Mhm.
have to owe either like, for example, like the remaining amount on their lease, or they'll owe their security deposit, whatever in the contract says, like, if you breach this, you'll have to do this. Okay. In order to have a valid contract, the good faith deposit must be paid in the form of A, cashier's check drawn on the bank's buyer's bank. B, cash money in small bills. C, a personal check drawn on the seller's bank. Or D, anything the party agrees on.
Is it A?
So shockingly, I think this is going to be
Oh,
D.
anything the parties agree on, I said that's it all.
So both parties sign like and agree that you pay them in cash or whatnot, then and they both sign a contract stating that that's what they agree. That is, let's check. Yeah. So the parties may agree on any form of payment for a good faith deposit or earnest money. Yeah. So another term for earnest money is going to be good faith money or good faith deposit. And definitely a good thing to know for the exam is like
Mhm.
good faith money equals earnest money deposit, but also earnest money is not required.
Right, okay.
Yeah. A large mirror that a large mirror that a buyer wants to remain with the property should A, never be included in the sales contract. B, be agreed upon verbally with its price stated in the contract. C, be disregarded as having no consequence. Or D, be identified as a fixture in the sales contract.
Is it D?
I believe it D, A or D. Good job. Yes. D. Be identified as a fixture in the sales contract. A fixture is defined as a piece of personal property that stays with the real property. Perfect. Good job. Once both parties have signed a purchase and sale agreement and the buyer's earnest money check is deposited into the broker's special trust account, whose money is it? A, the buyer's until closing. B, the seller's until closing. C, the broker's as a prepayment of commission. Or D, nobody's until the transaction is either completed, rescinded, or breached.
Is it D?
Do you say D or B?
Is D or B?
I know, right? I believe it is going to be D because your earnest money, whatever the buyer's earnest money amount is,
Mhm.
say it's like $5,000, that does get put towards their, put towards the purchase price at closing. Let's see. Okay, so it would be D, nobody's until the transaction is completed. Rescinded or breached. Until the offer is accepted, the money is in a sense the buyer's, but once the seller accepts the offer, however, the money may or may not get the money back, even though the seller will be entitled to it until the transaction is completed. Okay, that explanation is not helpful. But basically, it's nobody's until the contract is either complete or no longer. Okay, a purchase and sale agreement stipulates that earnest money deposit be placed in a separate interest-bearing account with an interest earned by split between the buyer and seller. This is A, not okay, and the broker should resign the listing. B, money laundering. C, okay, because the buyer and seller have agreed to it, or D, against the law.
Yeah, A.
I believe it is A.
What?
Because the
Oh, so if they agree to it, that's okay? I didn't know that.
right, so and basically anything goes if both parties agree to it. So good to know for the exam that like if both parties, like buyer and seller, agree to it, most
Mhm.
likely that is answer, and that in that case it is good. Okay. One sec, sorry.
Mhm.
Um, so everybody has to get reconnected to the printer. Like, so I just saw an agent behind me trying to get reconnected, so I was just texting them. Okay, so the landlord and the area real estate manager of a national real retailer both execute a lease and the cooperation fails to occupy the premise. What might prevent the landlord from enforcing the terms of the contract? Is that A, no corporate resolution granting signing authority to the real estate manager was approved? B, the real estate manager had authority to make the deal? C, the broker did not have a written listing? Or D, the economy declined and the retailer was closing other stores?
See?
Right? I think that is the best answer. Huh. No corporate resolution granting signing authority to the real estate manager was approved. No, this was tricky. So a broker should always make sure when the principals in a transaction are not personally executing binding documentation, that their representations have full authority to commit the principal to the terms of the obligation. That's just confusing. Interesting. Okay. So this is a tricky one, but most likely this won't be on your exam because it looks like a broker question. All right. If the buyer in contract for deed, land contract, who has paid less than 20% of the purchase price defaults, the seller may A, file a judgment lien, B, wait 10 days and then sell to someone else, C, initiate foreclosure proceedings, or D, initiate forfeiture proceedings. So it would be, this was tricky because land contracts are different, but if payments have been made totaling more than 20% of the purchase price, or if the contract has run for longer than 5 years, foreclosure proceedings are required. Judgment liens are involuntary financial encumbrances. I'm sorry, I'm reading this back. So if the land contract has been in place for less than 5 years, or the amount paid by the buyer is less than 20% of the purchase price, the seller may initiate forfeiture proceedings 30 days after giving the buyer notice of default and intent to sell. Oh, this is good to know. I did not know this. So if it's less than 20% and less than 5 years, it would be the forfeiture proceedings. But if it's more than 20% and more than 5 years, it would be foreclosure. All right. What is the best explanation for an option? A, legal procedure or action brought by either the buyer or seller to enforce the terms of a contract. B, document involved in closing real estate transactions. C, clause that grants either party the right to cancel a contract provided legal notice is given. Or D, agreement with consideration granting exclusive rights to buy or lease a property at a given price within a stated period of time.
D.
You say D?
Yeah.
That is correct. Good job. So an option is a unilateral contract that gives exclusive right to buy or lease property at a given price within a stated time period. Well, definitely knowing that definition will be very helpful for the exam, and knowing that an option is a unilateral contract. Okay. A seller and buyer agree on terms of a purchase and sale agreement and are now waiting for closing to occur. Unfortunately, before closing occurs, the improvements on the property are struck by lightning and totally destroyed. The buyer may A, terminate the contract, B, accept the property and claim the insurance proceeds, C, accept the property as is, or D, all of the answers listed.
D.
You say D?
Mm-hmm.
Correct. Good job. Just like we were saying before, if the buyer and seller both agree, then it's doable. Okay. The first instrument a buyer usually signs in a real estate contract is A, a mortgage, B, a deed, C, a listing agreement, or D, offer to purchase.
It's between C or D. C.
So this is for a buyer.
Oh, so maybe it'll be D then, offer to purchase.
Yeah, I think it's going to be D. Cool. Let's correct.
Yeah, okay. Because a listing agreement is like a real estate agent, right?
What?
The listing agreement will be, that's the real estate agent, right?
Yeah, so the listing agreement will be the first document, first instrument a seller signs.
Okay.
Yeah. But then when it comes to like the buyer, the first document they'll probably instrument for the transaction is going to be a purchase agreement. So once your buyer's like, hey, I want to put an offer on this house, the first document you'll send them is going to be the purchase agreement, or fill out with them is going to be the purchase agreement. Whereas a listing agreement is going to be the first thing you'll sign with the seller.
Okay.
Yeah. So yeah, that this one's tricky, but definitely making sure like one word, buyer, seller can change the whole answer. Okay. Okay. A condition or contingency in a contract can be waived by the A, lender's appraiser, B, property benefiting from the condition/contingency, C, broker for the seller, or D, broker of the buyer?
Position or contingency in the contract can be always- B? I'm not for sure about that one.
I don't know this one either. Are you saying B?
Mm-hmm.
Okay. Correct. Good job.
No, the
Party
best.
yeah. Educate, get. Good. That was your first instinct. Okay. Cool. Which is true of a voidable contract? Is that A, a forged contract is voidable? B, a signed real estate contract cannot be voided? C, all parties to the contract must have reached 16 years of age or can be voided? Or D, a voidable contract may be enforceable at the option of the innocent party? Mm,
Okay.
I want to say it's D.
B.
I remember this is a tricky one. So, which is true about a voidable contract? Yeah, D. So, sounds ridiculous, but basically, a voidable contract may be enforceable at the option of the innocent party. So, if it's like a minor or if they're, oh, here, so we go. So, only the injured party has the right to void a contract, but it is not required to. Reasons might include intoxication, menace or duress, fraud or misrepresentation, or minority status of one of the parties. If the contract is illegal, it is void automatically. So that it's kind of confusing in how they word it, but basically a voidable contract may be enforceable at the option of the party that is either misrepresented or in fraud. So kind of like rewording it to make it make more sense to you. But yeah, this was a tricky one. I only know that that's the right answer because I've gotten it wrong so many times. Okay. A legal remedy that would compel a vendor to execute a deed pursuant to a valid land installment contract is known as a specific performance, B, the equity of a redemption, C, execution of sales, or D, writ of execution.
B. Legal remedy that will compel vendor to execute a deed. Or is it specific performance?
Hmm. I actually am not sure what this was. A legal remedy that would compel a vendor to. Yeah, I'm not. Did you say B or D?
I said, let's try, I said A, specific
Yeah,
performance.
let's go with that. Well, your guess is as good as mine. Yay, good job. Specific performance is a remedy available to the buyer that would force the vendor to execute the deed and specifically perform the promises given in the land installment contracts. Good job. See, you do know your stuff. You just gotta be, you're like, yep, it's A. Move on to the next one. Right? It's so much easier said than done, though.
I know. It's when you get to the test and the words is so different from this. That's what's confusing. It's totally different from like the copygram or what you see in the book.
Right? It like is more modernized, I feel. Here,
Mhm.
like when you're taking the test, you're like, these sentences
Like what?
that don't make sense. Yeah.
They put words in there, you'd be like, I never even heard of this word.
Yeah, it's so true. Also, a lot of this is not the best advice, but like the ones that you're like, oh, I've never even heard of it. Like sometimes those maybe
Say that again. What's the last part you said?
Oh, so sometimes those may be the right answer when you're like, I don't even remember reading about this. But if
Mhm.
it's a definition you're not familiar with or doesn't, you're like, this is the first time I've ever seen this definition or anything about it,
Mhm.
I feel like the word that's least familiar is going to be the right answer in that case.
Okay.
Yeah. Um, and yeah, and then obviously definitely thoroughly reading the question and making sure like what you're reading, you kind of like put into your own words to then pick the best answer. And going with the one that catches your eye and you're like, I think it's A, it's just like just choose A, which is
Okay.
also hard. But process of elimination is helpful too. And then what other advice do I have? I'll upload my study guide that I had
Mhm.
that I did when I was studying for the exam. And I don't know if
Mhm.
I this to, but Quizlet is my go-to, or was my go-to to studying because it's free, and they use like questions, like obviously definitions are definitely flashcards, but they also have questions similar to CompuCram.
Okay.
Yeah, and I have in my study guide there's links to various Quizlets. Yeah. Okay.
Did that helped a lot too?
What was that?
That helped a lot too.
Yeah, that quiz studying on Quizlet did help a lot. I don't know. It's like there's so much material that any resource is good resource.
Yeah.
I would listen to podcasts, I would listen to YouTube videos, I would take practice tests, make flashcards.
Yeah, me too. I was what's the guy with that hat on YouTube?
Yeah. Oh my gosh. The agent prep.
Yes.
I know. Oh my god, he was like my best friend for months. Um, yeah, that's so funny. Gosh, I can't remember his name. Okay. So which has occurred when a contract has been rescinded and each party returns to the other any consideration that has been tendered? So which has occurred when a contract has been rescinded and each party returns to the other any consideration that has been tendered? Is it A, reconciliation, B, restitution, C, replacement, or D, restoration?
Okay.
Oh my gosh, so sorry. I feel like your B's and D's. Like, anytime you say B or D, I'm like, did you say B or D?
Mhm.
Did you say B?
No, I said A.
Oh, you said A. Oh, go me. I believe it is. Oh,
Oh, and I started to say that too.
let's see. Restitution is the rescission where the contract is undone, all obligations terminated, and all considerations returned. Reconciliation is the appraisal process to determine value by comparing different approaches. Oh, okay, I did not know. In real property terminology, replacement may refer to building improvements to the same functional and economic value as before. And then restoration may refer to reconstructing improvements to exactly the same physical status and appearance as before. All right. So yeah, this was a tricky one. But B, restitution is going to be the rescission where the contract is undone, all obligations terminated, all considerations returned. Definitely knowing each one of these definitions will be super helpful for the exam. These look familiar. So reconciliation, replacement, and restoration are all terms used in like appraisal or replacement value. So knowing the value of a property, whereas
Mhm.
restitution is going to be about the contract itself.
That's a good thing.
Contract law requires which amount of earnest money to be submitted with a sales contract? A, at least $1,000. B, 6% of the offer. C, no earnest money is required to form a contract. Or D, 10% of asking price.
See.
Perfect. B, earnest money is not an essential element of a contract and is not required to form a binding contract. Cool. That one will, something similar to that will probably be under text. All right. Good job. That was a hard section.
Mm.
Okay.
Let's do maybe practice a real estate.
Practice real estate? Sounds good. Yeah, I feel like that's a big. All right. Cool. Let's see. So what factor does not contribute to a buyer's market? Is that A, limited new construction, B, increased local job layoff, C, low affordable construction costs for both materials and labor, D, people moving away from the area?
Mm. See,
Sorry, which one did you say?
or is it? D?
You say B?
I
Do
don't
people
know. I don't know this one.
not contribute to a buyer's market?
Or is it A, limited new construction?
Maybe. Hmm. Good job. Yes. I was like, I'm that one sounds the best, but I feel like I was almost gonna say C. Limited new construction means fewer houses available and would contribute to a seller's market. That makes sense. So basically, the less homes, the better it is for a seller's market. The more homes on the market, the better it is for a buyer's market. And then prices will like, so that's why right now, for example, it's a seller's market because little inventory, so the buyers have less to choose from, so they're asking above asking price.
Right. Okay, I got you.
But vice versa, when there's lots of more houses for sale, then
Mhm.
prices are kind of pretty steady, like it'll sell for asking price or below asking. One day we'll get back there.
Right.
Right. So a real estate agent presents a full price cash offer with no contingencies during the initial listing period. The seller refuses to sign the contract because they do not like the buyers, which is correct. A, no commission can be due unless there is a closing. B, the listing contract would be automatically terminated. C, the buyer could sue for specific performance. Or D, the listing agency will most likely be due a commission.
D. Wait. The seller refuses to sign the contract because they do not like the buyer. A real estate agent presents a full cash price and no contingencies during the initial listing period. It will automatically be terminated?
I'm gonna say either B or C. Oh, let's
It
see.
was D. Wow.
Listing agency will
I
most likely.
said D at first too.
Oh, did you? Oh my gosh, see you knew. Right? So it's like in this case, you're just thinking of like what would the buyer and seller do? Whereas like the best answer even is gonna be D, because no matter what, that's gonna be the thing. But they confuse you by putting in these as well. Although sellers are not obligated to accept any offer on their home, the contract with the broker will most likely obligate them to pay a commission as the broker has done what they were hired to do. Hmm, that makes more sense. Like there could be like on the back end, uh, issue between the buyer and seller or legal things that can happen. but for sure, there's already a contract in place between the broker and the seller. So that's why D is the best answer. Wow, that was a hard one.
Mm.
Okay, so Kenny is the listing agent for a property and takes a weekend trip. When Kenny returns to office on Monday, he discovers 3 offers have been made for his listing. 2 offers are from competing brokers, and the third is an in-house offer. Kenny shows his seller the in-house offer and encourages the seller to accept it. After the seller accepts, Kenny calls the other 2 agents and tells them the listing is now pending. Kenny, A, should present all offers before encouraging a seller to accept one. B, didn't have to tell a seller about the other 2 offers. C, should cancel the listing. D, has done nothing wrong.
Mm. Can you?
I think someone didn't have to tell them. I believe it
I
would
said
be.
it's A, right?
Yeah. Like you're like Kenny's definitely in the wrong. And he has the um obligation to show the seller all offers no matter. Okay, perfect. All offers must be presented to a seller, even on a pending. So even if the property was under contract and you got another offer, you still have to ship it to the seller. Goldberg lists his home with PDQ Realty, allowing them to put a sign in the yard, list it in the MLS, and advertise it in the local newspaper. During the listing period, Goldberg sells the home to his brother and is not obligated to pay PDQ any commission. What type of listing did Goldberg have with PDQ? A, a net listing, B, exclusive agency listing, C, open listing, or D, exclusive right to sell listing?
Open or is an exclusive agency?
Right.
Isn't it?
So it's definitely not.
Well, we know it's not exclusive, right? Because that's the one that does get a commission, correct?
Yeah. And that's the one that is used in Ohio.
Right.
Mhm.
Allowing them to put a sign, listing in the MLS, advertising. So let's do open.
Open? Okay.
Oh my God.
So between both of them, right? Yeah.
Not
This a
that.
similar question like this will definitely be on the exam. So under an
So it's
exclusive agreement, the seller can sell the property on his own and not owe a commission. Got it. Okay, so then an exclusive agency listing, unlike an open listing, only the listing company can put a sign in the yard and advertise it. Oh, okay, so in an open listing, they cannot put a sign in the yard or
right.
advertise,
Okay.
but in an exclusive agency, they can. I couldn't remember what the difference was. Okay. Seller Steve calls a real estate agent to list his home. Steve tells the agent that he wants $156,000 in his pocket at closing, and the agent can have the rest for the commission. What type of listing would this be? A, a net listing, B, exclusive right to sell listing, C, exclusive agency listing, or D, open listing?
B. B.
B?
B. Mm-hmm.
Okay,
Oh,
let's see that thing. Okay, so net listings are illegal in some states and frowned upon in others, as these situations are breeding grounds for fraud and unhappy clients and agents. Mm, Okay, so it doesn't even tell you the example of a net listing, but basically, then in this case, the listing agent could price the property however much they want so that they get a lot of commission. So that's why it's frowned upon and illegal. So net listings are not a thing and exclusive agencies are not a thing. Same with open listings, but definitely knowing the difference between each one will help for the exam. But know that once you pass the exam, we only use exclusive right to sell listings, so you'll never have to worry about this again.
Right.
Right? A broker must keep records of all funds received and disbursed from the broker's special trust account, which does not need to be included in the record. A, amounts received. B, client social security numbers. C, check numbers and date funds are dispersed. D, date funds are received.
B.
CP? Correct. Good job. A broker who engages in commercial or residential property management must have a special property management trust account to receive security deposits, rents, and other funds from tenants. This account may earn interest. Who is the beneficiary of the interest on the rental receipts? Is it A, the property owners receive the interest? B, the state is entitled to the interest through a sheet? C, the property manager has earned the interest as a bookkeeping fee? Or D, the tenants should receive monthly pro rata payments?
So is the property owner?
That one sounds, yeah, that one sounds best to me too. Yeah, good job. Wow, these are tough ones.
They are.
Yikes. This is like, what? With commercial and broker? Like, this should be a broker question. The difference between fraud and misrepresentation is that A, fraud is intentional misrepresentation, while misrepresentation may be unintentional. B, there is no difference between fraud and misrepresentation. C, fraud is unintentional, while misrepresentation is an intentional act. Or D, a buyer can recover only compensatory damages for fraud.
Okay.
Did you say C or did you say B? A? Correct. Good job. Fraud is defined as intentional misrepresentation of a material fact, while misrepresentation may be an inadvertent misstatement of fact. It is fraud is proven. It can give rise to both compensatory and punitive damage. Got it. Good job. So fraud is intentional, and then misrepresentation may be unintentional. Cool. So Carol, a broker, doesn't want her husband to know she received a commission check for $35,000. So she put the money in her non-interest bearing broker's trust account that she maintains for her clients. Carol is guilty of A, conversion, B, self-dealing, C, commingling, or D, cooperation. Oh, where's
C.
Carol from this?
Right.
Right?
C.
C?
Mm-hmm.
Good job. Yes, commingling. Mixing a broker's money with a client's is commingling. When an agent uses money that belongs to others is called conversion. Cool. Yeah, definitely knowing those differences. So when an agent uses money that belongs to someone else is called conversion, but then when money is put into the trust account,
Mm-hmm.
it is commingling. Okay. During a listing interview, a seller demands the listing agent reduce the proposed commission by 1%. What is the best course of action for the agent? A, explain the commissions are generally fixed in each locality. B, refuse the listing as commissions are not negotiable. C, go ahead and reduce the commission. D, call the broker and discuss the matter.
B.
You say B?
I don't know. D or B.
Oh, D, yeah. No, broker doesn't matter. Go ahead and reduce the commission. Explain the commission are generally fixed.
I think it's D.
Yeah, good job. Yep, D is correct. An agent should not adjust commissions without the consent of the broker. Good job. Agree. A buyer looking at a rural property asks the salesperson if they should have a well and septic inspection. The agent advertises that they may lose the property to another buyer if they make the contract contingent on an inspection. Which best describes the situation? A, the agent was acting carelessly. B, the broker is only one liable. C, the agent was looking out for the buyer. Or D, the buyer got good advice.
Mm, A.
A or C? Good job, A. Good job. A broker agent is expected to use reasonable skill and care when representing a client. An agent should never discourage a buyer from having an inspection performed. Yeah, good job. Yeah, even if it's like you're in multiple offer situation, whatever your client wants to do or chooses, you should always do that. Basically, you're the one working for your client. All right. Commingling refers to A, meetings with the brokers and sales associates present, B, employing realtors and non-realtors in the same office, C, cooperating with another broker in a transaction, or D, depositing clients' funds in the broker's operating account.
D.
Correct. It's going to be D. That is the definition of commingling. All right. What factor does not contribute to a buyer's market? Oh, we know this one. A, increased local job layoffs. B, people moving away from the area. C, low affordable construction costs for both materials and labor. Or D, limited new construction.
D.
Yeah. Whoa.
Mhm.
Okay. An earnest money deposit, if any is offered, is usually given to the broker at the time a sale contract is authorized by the offerer and presented to the offeree. Absent any contrary instructions in the sales contract, the broker has legal responsibility to A, hold the check in the transaction file until closing, B, deposit the check in the broker's special trust account, C, put the check in the broker's fireproof safe, D, deposit the earnest money in their operating account.
B.
Correct. It is B. All right. A sales agent is about to take a listing. The sellers indicate that they do not wish to have the property shown to anyone of a certain racial background. The real estate agent complies with the seller's request. Which statement is true? A, the seller agent has no liability as they were following the seller's request. B, the broker has no liability for the sales agent's act. C, the broker is liable of the sales agent's misconduct, even though the broker did not know of the discriminatory acts. Or D, the seller has no liability since the sales agent will be the only person showing the property.
C.
Mhm. Correct. Yep. It is C. Right. Good job.